Before we get started, I want to begin by saying that due to the stock market and real estate crash of 2006 to 2008, the enforcement of the laws that we will be talking about today were previously enforced by HUD. Though HUD still exists and does have some responsibility, it was stripped of its total responsibility regarding the federal laws as they relate to the home buying process. The Consumer Financial Protection Bureau is now the enforcer of the federal laws we will be discussing unless otherwise specified. So, let's begin by talking about Respa. When we talk about Respa, we are referring to the Real Estate Settlement Procedures Act. The Real Estate Settlement Procedures Act is a federal law that is enforced by the Consumer Financial Protection Bureau. Respa's goal is to be able to provide consumers with more timely information on the nature of the costs during the settlement processes. Respa is known as Regulation X, which I remember with the T-Rex dinosaur. I like to think of it as T-Rexpa. The T stands for the timing of the information throughout the settlement process, and X is for Regulation X. So altogether, we get T-Rexpa. Now, when I say that the T in T-Rexpa stands for the timing of the information regarding the settlement processes, what do I mean? Well, what I'm talking about is the disclosures that are given at specific times to help consumers understand the settlement costs associated with their loan. So you can think of it as an action. And when you have an action, you need a reaction. Well, Respa states that if the borrower takes a specific actions to be considered for a loan, a mortgage loan officer, lender, or other entity involved in the loan process must respond with a specific reaction within a specified period of time. It's important that you know what Respa does and does not apply to. So let's first talk about Respa and what it does apply to. Respa applies to residential properties that are 1 to 4 units and are owner occupied. Again, Respa applies to residential properties that are 1 to 4 units that are owner occupied. The SAFE test doesn't only care about what rules apply, they're also testing your knowledge about what these laws do not apply to. So it's important that you remember that Respa does not apply to commercial property, agricultural property, vacant land, or temporary financing. Again, Respa does not apply to commercial property, agricultural property, vacant land, or temporary financing. Now, a way that I remember that Respa does not apply to these things is through the acronym called CAVIT, which is spelled CAVT. So let's break down what these things mean according to Respa. Well, the C in CAVIT stands for commercial property. Commercial property, according to Respa, is anything that has a business that provides goods or services. The A in CAVIT stands for agricultural property. Now, when we talk about agricultural property, it's important that you know that we are always talking about 25 or more acres. So remember, agricultural property equals 25 or more acres. The V in CAVIT stands for vacant land. This one they will use to trick you because there is an exception to vacant land. So in your notes, put an asterisk up by the letter V in your acronym to remind you of the exception associated with vacant land. Vacant land does not apply to Respa unless, that's the exception, unless a dwelling is intended to be constructed on the land within 2 years. So what this means is that if a 1 to 4 unit residential property that is owner occupied is built on the land in less than 2 years, Respa does apply. But other than that one exception, Respa does not apply to vacant land. And finally, the T in cavity stands for temporary financing. It's critical that you understand what some examples of temporary financing are. One is known as a bridge loan, which we will discuss more in detail in a later module, but what you need to know about a bridge loan for the purposes of Respa is that it is a loan that is used to bridge the gap of financing to purchase a new home before selling an existing residence. Another example of temporary financing is known as construction loans. So, just to recap, we need to remember that Respa does not have cavities, meaning that Respa does not apply to commercial property, agricultural property, vacant land, unless an owner-occupied 1 to 4 unit residential property is to be constructed on the land within 2 years. And lastly, Respa does not apply to temporary financing such as bridge loans and construction loans. Now, using this knowledge we've just learned about Respa so far, let's try a question that you may see on the test. Remember, we're looking for the most correct answer when we're answering questions both in practice and on the real exam. So a question may state, a property that Regulation X applies to would be A, a 4-unit plaza occupied by the owner's business, B, a 29-acre property with a duplex occupied by the owner and a tenant, C, a vacant property that is intended to build an owner-occupied triplex in 3 years, or D, a 24-acre property with a fourplex occupied by the owner. Take some time to answer and we'll go over it together. Now let's use the process of elimination to find our answer. Answer A states, a 4-unit plaza occupied by the owner's business. Well, we know that the C in cavity stands for commercial property, so a 4-unit plaza occupied by the owner's business would not apply to Respa. So let's cross that off. Answer B states, a 29-acre property with a duplex occupied by the owner and a tenant. Well, we know that the A in cavity stands for agricultural property, and agricultural property is anything that is 25 acres or more. So with this answer having 29 acres, we know this can't be the correct answer. So now we have answers C and D to choose from. Well, answer C says a vacant property that is intended to build an owner-occupied triplex in 3 years. So what this answer is talking about is vacant land. And even though it does meet the criteria of Respa by anticipating to be an owner-occupied triplex, the key here is that it isn't intended to be built for 3 years. And what we know about Respa is that Respa can only apply to vacant land if the property is intended to be constructed in 2 years or less. So this answer is not correct. This leaves us with the correct answer of D, which reads, a 24-acre property with a fourplex occupied by the owner. This answer meets all the criteria of a property that Respa does apply to. Remember, the test will try to trick you with the small little details and exceptions to the rules, which is why it is essential you don't just know the definition, rules, or facts for the test, but you understand how all of these work together in sample scenarios just like this one. Now, it's important that you know that Respa has 4 sections that are necessary to understand for the SAFE exam. These are known as Section 6, Section 8, Section 9, and Section 10. Section 6 provides borrowers with important consumer protections relating to the servicing of their loans. Again, Section 6 provides borrowers with important consumer protections relating to the servicing of their loans. Now, when we talk about servicing as it relates to the loan process, we are referring to the company who is responsible for things like collecting monthly mortgage payments, paying taxes on the borrower's behalf, as well as paying the insurances associated with the loan, in addition to other items as they come due, as well as notifying the borrower of late payments. For example, if a borrower finds an error or has a complaint regarding the servicing of their loan, according to Respa Section 6, the borrower can submit what is called a qualified written request, or a QWR. And a qualified written request requires the acknowledgement by the mortgage servicer of receipt of the complaint within 5 business days, and the mortgage servicer must seek to resolve the error or complaint within 30 days. Now, the way that I remember that Respa Section 6 deals with servicing is because the number 6 and the word service both start with the letter S. So we can remember that Respa Section 6 has to do with servicing. Now, Respa Section 6 also states that the mortgage servicer must post a payment the day it is received, and it requires them to respond to a payoff request within 7 business days. Remember, Respa Section 6 is in the business of protecting the borrower from servicing abuses, so there are a lot of requirements it imposes on the mortgage servicer to prevent those types of servicing abuses. Respa Section 6 also requires that creditors need to disclose to the consumer 45 days before they put force-placed insurance into effect and bill the customer for it. So again, Respa Section 6 requires that creditors notify consumers 45 days before force-placed insurance is put into effect and billed to the customer. A side note here, when we talk about force-placed insurance, what we're talking about is the insurance that is imposed on a borrower when the borrower's own insurance coverage has lapsed and is seen as insufficient to adequately protect the lender's interest in the home. Now, we'll talk more about force-placed insurance in another module, but I just wanted to put that in there just so that way you understood how force-placed insurance works. Respa Section 6 also states that a lender must attempt to make live contact within 36 days with a borrower who has missed a mortgage payment. Now, even if the lender doesn't get in touch with the borrower, all that matters is that they attempted to make live contact. This next part of Respa Section 6 is one of my personal favorites because it really shows the links that mortgage servicers are required to go to when trying to help a borrower prevent foreclosure. For example, Respa Section 6 states that a creditor must provide a borrower with mortgage workout options within 45 days of a missed payment. So what this means is that a lender can't just say, whoops, sorry, you missed a payment. Well, now we're going to foreclose on your house. No, Respa Section 6 states that they must provide the borrower with workout options within 45 days of a missed payment. So some of these workout options may include loan modification, forbearance options, and short sale options as well. In addition to that, Respa Section 6 states that if there is an option to save the home, the creditor is responsible for notifying the borrower within 30 days after submission of a complete loan workout application. And lastly, Respa Section 6 prohibits dual tracking. Now, dual tracking is defined as continuing to pursue foreclosure while the borrower is being considered for workout options. In fact, it's because of Respa Section 6 that a creditor cannot pursue judicial foreclosure or a trustee's sale action for 120 days for a borrower who is delinquent. those 120 days are crucial because what they do is that they give the borrower the opportunity to follow through on those workout options in an attempt to save the home.